You know that feeling, right? When you're waiting for something really important to happen, maybe a new policy or a law change, and it just feels completely stuck.
Oh, absolutely. Like wading through treacle. You keep checking, trying to figure out what the holdup is.
Exactly. And that feeling, that desire to really understand how the system works or sometimes doesn't work smoothly, that's what we're diving into today.
It is. Because beneath the surface of how we think things run, there are these fascinating interpretations, sometimes really unexpected ones.
And today's topic comes from a lecture that's, well, it certainly stirred things up.
Hmm?
It was given by former Supreme Court Justice Jasti Chelameswar.
Right. A very respected legal mind.
And you might think you've got the basics down, President, Parliament, Supreme Court, the checks and balances in India. But Justice Chelameswar, he kind of dropped a bombshell.
He really did.
He argued quite forcefully that the Supreme Court actually has the authority, the power, to issue directives to the President of India, to tell the President what to do.
It's a statement that definitely makes you stop and think. The judiciary telling the head of state what to do, I mean, that sounds like it pushes against the usual understanding of separation of powers.
It does. We generally think of these branches, legislative, executive, judicial, as having their own distinct lanes, to prevent anyone getting too powerful. His argument seems to, well, redraw those lines a bit.
And the setting for this was quite something, too.
Yeah, it was at the Rakesh Endowment event, and it was marking the 75th anniversary of India's constitution. So a really significant backdrop.
Absolutely. Imagine the room inching, legal experts, scholars, people deeply invested in the Constitution. Hearing this claim in that context, it adds weight.
It wasn't just some throwaway comment. Definitely not. The 75th anniversary naturally invites reflection on how the Constitution has evolved, how it's interpreted.
And, his points would have been picked apart, debated intensely by that audience.
So the big question that jumped out at me, and I'm sure you're thinking it too, is does the Supreme Court actually have this authority? Can it really instruct the president?
That's the core of it. We need to look at his reasoning, the context, maybe some real-world examples.
Right, and maybe uncover a bit of constitutional, dare I say, sass. It's about the real dynamics of power.
It's definitely more than just dry legal theory. It has real implications. Let's get into it.
Okay, so let's break down his main point. Justice Chelameswar's central claim. The Supreme Court can, in fact, direct the president. What's the logic he presented?
Well, his reasoning, as I understand it, is built on something the Supreme Court already does. It has the power to strike down laws passed by Parliament if they violate the Constitution.
A huge power, obviously.
Right.
Checking the legislature.
Exactly. So he argues, if the court can do that a law made by the people's representatives, then logically, shouldn't it also be able to ensure that public officials fulfill their constitutional duties?
Including the president?
Including the president. He put it very directly. Something like, if you and I, sitting as judges, can strike down a law passed by Parliament, it's a bit rich to think we can't tell a public office holder to do their job.
That's very plain language. Almost a common sense kind of argument. If you can undo a law, surely you can nudge an official to follow the existing rules.
It frames it as a matter of basic accountability,
Yeah.
doesn't it? And ensuring the whole constitutional system actually functions. If the court can correct Parliament's mistakes, why should it be powerless if the executive branch seems to be, perhaps, neglecting a duty?
And this wasn't just abstract thinking for him. He tied it directly to something very recent, didn't he? This Supreme Court order about bills needing assent.
Yes, that was a key trigger. The Supreme Court had recently issued an order basically saying that the president and state governors need to give their assent to bills passed by state legislatures within a reasonable time.
Okay, what was the backstory there? Why did the court need to step in?
Well, the immediate context involved significant delays. Bills passed by state assemblies, particularly highlighted in the case of Tamil Nadu, were just sitting waiting for assent for a very long time in some cases.
Right, I remember Tamil Nadu was a big example. Their state government passed bills and they just stalled.
Pretty much. Stuck in limbo at the governor's desk, or potentially waiting for presidential assent later. And these weren't minor issues. They were laws the state legislature had approved.
What kind of impact did that have? I mean, beyond just frustration for the lawmakers.
It had a real impact on governing. Policies couldn't be implemented. Initiatives were stalled. It creates a kind of paralysis. And ultimately, it affects the people who are waiting for those laws to take effect. So the Tamil Nadu government felt their legislative work was being effectively blocked.
Which led them to the Supreme Court.
Exactly. Prompting this order about reasonable timeframes for assent.
Maybe we should quickly touch on the basics here. what is the president's and governor's role in this assent process normally?
Sure. So while the president's role is often described as ceremonial in many ways, giving assent to bills is a key constitutional function, especially for certain state bills. At the state level, a bill passed by the legislature goes to the governor.
And the governor signs it into law, usually.
Usually. Or they might reserve it for the president's consideration, particularly if it touches on matters in the concurrent list or seems to conflict with central laws. That's where the president comes in sometimes for state legislation.
Okay, so the process exists, but the problem is when that final step, the assent, gets delayed indefinitely.
That's the crux of it. The argument is that unreasonable, indefinite delays can effectively veto legislation without saying so. It frustrates the state's legislative power and creates uncertainty.
Which brings us back to the controversy around the Supreme Court's order. Not everyone agreed that the court telling the president or governors to act within a time frame was the right move.
No, definitely not. There was pushback. Concerns were raised about judicial overreach. A prominent voice expressing this skepticism was the Vice President, Jagdeep Dhankhar.
What was the main argument against the court's directive? Why did people like the vice president feel it might be going too far?
The core counterargument often centers on the president's constitutional position. The reasoning is that the president doesn't act independently in these matters, but on the advice of the Union Cabinet, the central government.
Ah, right. The aid and advice clause?
Precisely. So the argument goes, if there's an issue with delay, the court should perhaps be directing the government that advises the president, not the president directly, targeting the source of the advice, essentially.
And Justice Chelameswar actually acknowledged that nuance, didn't he, in the Q&A after his talk?
He did. He suggested that, yes, the Supreme Court could have taken a slightly different route, perhaps directing the Union government to tender its advice to the president within a set time frame.
A more indirect approach.
Exactly. He even quipped that this might have avoided some of the hullabaloo, his word, that followed the direct order. So he recognized the political sensitivity.
Interesting. So he saw that maybe there was a less confrontational way to achieve the same end, but did that change his fundamental stance?
Not at all. Despite acknowledging that alternative, he firmly reiterated his main point. He concluded, quite clearly, the president can be directed by the Supreme Court.
Wow. So even if there are other ways, he maintains the underlying authority exists.
That seems to be his core conviction. The power is there, even if its exercise needs, perhaps, careful consideration of the circumstances.
Let's circle back to Tamil Nadu then, because it really does feel like the textbook case for why this isn't just theoretical legal debate. What happened there, step by step?
Okay, so the DMK government in Tamil Nadu passed several bills, key pieces of legislation for their agenda. But these bills got held up, waiting for the governor's assent for months in some instances.
Which must have been incredibly frustrating for them.
Immensely. They felt their democratically passed laws were being stalled without clear constitutional reason, so they took the matter to the Supreme Court.
Seeking intervention.
Yes. And that case was instrumental in the Supreme Court, laying down the principle that assent, whether from the governor or the president, must happen within a reasonable time. You can't just sit on bills indefinitely.
And this really puts the spotlight on that tension in federalism, doesn't it? The balance between the state's power and the center's oversight.
Absolutely. It's right at the heart of it. From the state's perspective, these delays look like an encroachment on their autonomy, their right to legislate for their people.
But what's the counter perspective? Why might the center or the governor argue for caution or delay?
Well, the argument might be about ensuring consistency with national laws, or perhaps concerns about the constitutionality or broader implications of the state law. Governors and the president, when involved, are seen by some as checks to ensure state laws align with the larger constitutional framework.
So it's state autonomy versus legal harmony, in a way.
It's a very delicate balance, and one where, arguably, this citizen waiting for the law to take effect gets caught in the middle.
Justice Chelameswar also brought up this legal concept, repugnancy. Sounds complicated. Can you simplify it for us?
I'll try. Basically, repugnancy comes up when a state law conflicts with a central government law on a subject where both can legislate something from the concurrent list in the Constitution.
Okay, so state law says one thing, central law says another. Who wins?
Generally, the central law prevails.
Yeah.
Article 254 of the Constitution says that. Unless, and this is the key part, unless the state law, even though it's conflicting, has received the assent of the president.
So presidential assent acts like a special approval that lets the state law override the central one within that state.
Exactly. It's a specific constitutional mechanism to allow for state-level variations even when there's a conflict. Think of it like getting a special permit.
Okay, I think I get that. So where do the delays in assent become a problem here?
The problem arises if the president just doesn't decide. If they indefinitely withhold assent for a state law, that might be repugnant to a central one. The state law is passed, but it can't get that special status to prevail because the assent is pending forever.
It creates a sort of legal limbo. The state can't move forward with its law effectively.
Precisely. It becomes a bottleneck. And the Supreme Court's order for time-bound assent tries to address this. It prevents the president from effectively blocking state laws simply through inaction in these repugnancy cases.
Which ties back perfectly to that pointed question Chelameswar asked.
Yes, his rhetorical question. If the president doesn't want to give assent, what do we do? Just twiddle our thumbs.
It really highlights the potential for paralysis if there's no mechanism to compel a decision.
Exactly. It underscores the need for the system to have some way to resolve these situations. Otherwise, the state's legislative power in these concurrent areas could be seriously undermined.
Now, moving slightly broader, another judge present, Justice G.R. Swaminathan from the Madras High Court, asked about the Constitution's journey overall. How did Justice Chelameswar respond to that?
He gave a very measured, thoughtful answer. He described the Constitution's journey not as a sprint, but as a long march.
A long march, implying it's ongoing, maybe difficult?
Yes, I think that's dissent. He emphasized that there aren't always easy overnight solutions to the constitutional challenges that come up in a democracy like India's. He acknowledged the debates, the tensions, like the very one about presidential directives they were discussing.
So he sees these debates not as a sign of failure, but as part of the process.
Precisely. He seemed to view the Constitution as a living document. It evolves, it adapts through these interpretations, these judgments, these interactions between the different branches. The arguments themselves are part of its lifeblood.
These moments of friction are actually how it stays relevant.
That seems to be his perspective. They're integral to its growth and its ability to meet new challenges over time.
And just finally, on the event itself, the Rakesh Endowment, it had personal significance too, didn't it?
Yes, it was organized as a tribute to Rakesh Ranganathan, who was the late son of a senior advocate and MP. Choosing the 75th anniversary of the Constitution as the theme was seen as a very fitting way to honor his memory by fostering this kind of important constitutional discussion.
A meaningful context for a weighty topic.
Yeah.
So, let's try and wrap this up. The key takeaway really seems to be Justice Chelameswar's bold assertion. The Supreme Court can direct the president. Its authority might reach further than traditionally assumed.
That's definitely the headline point. It challenges conventional views on the separation of powers and suggests a potentially more assertive role for the judiciary in ensuring constitutional duties are met, right up to the highest office.
And we've seen this isn't just abstract legal musing. It connects directly to real issues like legislative delays, the functioning of federalism, things that affect how the country is actually governed.
Absolutely. It's about the efficiency of the government, its responsiveness, the balance between the center and states. These are not small matters. They impact citizens' lives directly.
So perhaps a final thought for our listeners to ponder. What does it really mean for a democracy if its head of state can be directed by the judiciary? What are the potential long-term effects on that delicate dance between the branches of government?
A fundamental question about checks and balances, isn't it? How do you ensure accountability without upsetting the equilibrium? It's a constant negotiation, an ongoing part of India's constitutional story, something definitely worth keeping an eye on.